Hello everyone, welcome to Authentic Forensic Medicine. Students, in today's video, we are going to discuss important topic of types of courts. And Another important topic is capital punishment. These are the topics from which many times the MCQs very commonly come. They are very important Viva questions and sometimes even the short notes are asked. So let's start the today's PowerPoint presentation. Now, students, before we try to understand the types of courts in India, before that we need to understand the types of cases, legal cases in India. Now, broadly, they're classified into two types. The first one is the civil cases. The other one are the criminal cases. Now, I think we all understand what do we mean by civil cases and criminal cases. Now, civil cases are those cases where the dispute is between two parties. There's no crime has happened, but two parties have some disagreement and they want to take the help of the court to resolve that matter. The complainant is one of the party. One party is complaining against the another party. These matters go to civil court. Example, medical negligence cases. The cases where the patient feels that he is not satisfied with the treatment of the doctor and wants to have a compensation can go to civil court. The cases of divorce, the husband and wife have some problem, they can't stay together, they want divorce, they can go to civil court. Or there's a dispute of custody of child, that who will keep the custody. The child will stay with the mother or the child will stay with the father. And they are not on agreement, they can go to the court and take the justice. And consumer disputes, like you have brought something from the market, a fridge or television or some other device or some other instrument or gadget or vehicle. You are not satisfied that vehicle company is not listening to you. You can go to civil court and ask for compensation. Insurance claims, some problem with the insurance claims, again civil matter. So in all these cases, the matter goes to civil courts. Now the standard of proof. In these matters, the standard of proof, that how much a thing needs to be proved. The principle is called preponderance of the evidence. What is the meaning of preponderance of the evidence? The preponderance of the evidence means that in these cases, even if there is a slight weightage towards one party, if the judge feels, if it is proved in the court that about more than 50%, it looks like that one party is faulty and other party is the victim, the decision will be given in the favor of the victim. The matter did not need to be proved 100%. The case did not need to be proved 100% in these cases. It's like the balance. If the one party is able to prove more than 50%, like it seems that yes, he is the victim, the other party needs to pay compensation, the judge will give a decision in the benefit of the one party. This is called preponderance of the evidence. Evidence seems to be in favor of one party. So these are the civil cases. But things are different in criminal cases. In criminal cases, the case is not between two parties. Case is against the accused by the government. The public prosecutor, the lawyer appointed by the government, the public lawyer, fights the case, files the case on behalf of the state government. Why? Because it is the responsibility of the state that no crime should happen in the state. It is the responsibility of the government to reduce and control the crime. Crimes are not acceptable in any civilized society, in any civilized country, in any civilized state. Whenever a serious crime like murder, rape happens, it is the duty and job of the government, elected government, that accused is punished. So the government fights the case. The public prosecutor is fighting the case on behalf of the government. So person who is accused has done a public wrong. Offense is against the state. A person killed. Yes, a person has been killed by somebody. The family of the person who's died is the victim. They are suffering. But it's a public wrong. It is wrong against the whole society. Crime is not acceptable. So case will be fought by the government. The family of the person who has died does not fight the case. They want justice, but the case is fought by the government. These cases are fought in the criminal courts. The courts have here the power to give punishment to the accused. Person can be sent to jail And very, very serious crimes like murder, cold-blooded murder, the courts have the power to give death punishment to the accused. In civil cases, the punishment is not imprisonment or death. No. Punishment in civil cases is to pay compensation, is to pay damages. Damages mean compensation for whatever the damage has been done. The accused has to pay the fine. Now, in this case, the standard of proof is beyond reasonable doubt. In civil cases, it was preponderance of evidence. The evidence seemed to be in favor of one person. But in criminal cases, it has to be proved 100%, more than 99%, 100%, about 100%, that accused is guilty. Why? Because here one person will be sent to jail. And before sending him to jail, the accused, it has to be proved that he has committed the crime. It has to be proved beyond reasonable doubt. Beyond reasonable doubt means almost 100%. There should be evidences that this person is the person who has done the crime. Then the court will send that person to jail or give death punishment. We cannot otherwise spoil the life of a person without proving it and send him to jail. No, that cannot happen. Party needs to prove that his version of the facts is highly likely. And these are very, very serious cases like assault, robbery, murder, arson. Arson means setting fire to a building, rape, etc. These are very, very serious cases. Now let's try to understand the hierarchy of courts in India. Now students, in India, the topmost court, the highest court in India is the Honorable Supreme Court of India. I think we all know that. It's located in New Delhi. There's only one Supreme Court in India, highest court. Whatever decision is given by the Supreme Court is applicable to all of India. All the courts have to agree. Whatever rules are made by Supreme Court of India, guidelines are made by Supreme Court of India, they are applicable to all the states, all the high courts, to all the police. Next is high courts. High courts are subordinate to the Supreme Court of India. Each state has its high court. In India, most of the states have their own high courts, and most of these high courts are located in the capital city of the state, except a few. In some cities, some states like in Uttar Pradesh, the capital is Lucknow, but the high court is in Allahabad, which is now called as Prayagraj. The high court is in Prayagraj or Allahabad. Some states share a high court. For example, the Punjab and Haryana they have one high court which is located in Chandigarh in the Union Territory. Another very important point is, which comes as MCQs, who appoints the Chief Justice of India? Who appoints the Chief Justice of India? The answer is President of India. The President of India makes the Chief Justice of India take the oath and appoints him as Chief Justice of India. Another important MCQ which comes in exams, who appoints the Chief Justice of High Courts in India? And most of the time students do the mistake that they take the wrong answer. The Chief Justice of High Court is appointed by Chief Justice of Supreme Court of India, which is wrong. Even all the Chief Justices of the High Courts are appointed by President of India. So please do remember this very important MCQ. Chief Justice of India and state high courts are appointed by the President of India. Now another very important point about Supreme Court and High Court is that these are appellate courts. Please do remember these are the courts of appeal, appellate courts. Appellate courts means that these courts do not take direct cases. A criminal case or civil case between two parties cannot go directly to High Court or Supreme Court. These are the courts of appeals. When the matter has been, when the case has been fought in Supreme Court, in the district court, when the case has been fought in district court or session court, which are the district level courts, and if one party is not satisfied with the decision, they can go and appeal in High Court. If they are not satisfied with the decision of High Court, they can go and appeal in Supreme Court. So appeal can be filed in High Court or Supreme Court, but direct cases cannot go to High Court and Supreme Court. Supreme Court handles those cases which are of interest to the whole nation, which are of national level importance. For example, some public interest litigation, a matter which will affect the whole population of India. In that matter, a person can go and file a case to Supreme Court of India. For example, pollution. For example, some decision policy taken by the government with some people do not agree. They think that this policy by the government is not in favor of the people. when there's a dispute between two states having a dispute, that dispute will be solved by the Supreme Court of India. Similarly, the high courts of a state also take the cases which are of importance for that state, which are important of state levels. Public interest litigation about state can go to high court. A dispute of state level can go to high court. But high court and Supreme Court do not take individual cases. Only they can, somebody can appeal to them, but that cases cannot be. So whenever there is a civil case, it goes to district court. At district level, there are two types of courts. One is district court, one is session courts. If there is a criminal case, it will go to sessions court. If there is a civil case, it will go to district court. The judges in district court and session court are of the same level, the same powers, same seniority. They can be of same. Same judge can be sitting in district court handling a civil case. Same judge can be sitting in session courts and handling a criminal case. But there are other junior courts. These are the higher level courts of district level. Below district courts, there are sub courts where senior civil judges are there. There are principal junior civil judges court, and there are municipal courts. So these are the junior level courts, junior most courts from where the civil cases start. So civil cases can go to these courts up the hierarchy to district level. And criminal cases, they start at judicial magistrate courts, the second class magistrates. They can go to first class magistrates and finally to the sessions court where the highest judge in the district is sitting. So this is the hierarchy of the courts in India, which we need to remember as doctors. But why do we need to remember them as doctors? That's a very important question. Why we need to learn these laws and these codes? Because we as doctors are treating patients. Patient may be a victim of a crime. There may be a patient who has been tried to be killed. A patient who has met a serious accident and somebody will be accused. And we will have to go there as witnesses. Doctor has to go there in these cases as witness. When doctor is attending a patient who is a victim of a crime, a victim of a rape, victim of attempt to murder, we as doctors become witness. And sometimes we can also be accused. Doctor can also be accused by the patient. A patient dies, a patient's family files a case against the doctor. So doctor also has to go to court to answer these cases. So we as doctors need to understand this hierarchy of court for our own welfare, for our better. So let's move to the next slide. Now, what are the powers of these courts? Supreme Court of India has the highest powers. It can give all kinds of punishments. Maximum fine, there is no restriction on the amount of fine compensation the Supreme Court can give. It can give imprisonment to a person in a criminal case up to for the whole life. And can also give death sentence. Death sentence we will discuss is given very, very rarely, but Supreme Court has the power to give any kind of punishment to the accused. High courts also have all the powers of punishment, same as the Supreme Court. There is no difference in the level of punishment of the powers of High Court and Supreme Court. High Court can also give death punishment and any imprisonment, any fine of any amount. Now, district courts, session courts, they can also give death sentence, but the death sentence given by the by the session court. District courts do not give death sentence. District courts handle civil cases. Session courts give death sentence, where they are handling criminal cases. So session court when give death sentence, this death sentence has to be confirmed by the High Court. Very, very important MCQ. A death sentence given by the sessions judge in the session court has to be confirmed by the High Court. High Court has to give approval to it. But they can give fine of any amount. Assistant session judge cannot give death punishment. They can only give imprisonment up to 10 years. Chief judicial magistrates can give up to 7 years. Chief judicial magistrates are known as chief metropolitan magistrates if it's a metro city. If it's a normal city, non-metro city, they are called chief judicial magistrates. If it's a metro city like Mumbai or Delhi, they are called chief metropolitan magistrates. So they can give punishment up to 7 years. The first class judges can give punishment up to 3 years. And the second class judges, who are the junior most judges, can give punishment up to 1 year. So these are the level of punishments and the level of fines. So second class, the minimum fine which can be given is 5,000. Maximum by the second class judge. The maximum fine given by the first class judge is 10,000. So this can come as MCQ. These are your MCQs. So let's move to the next slide. Now coming to another types of courts in India, labor courts. Now labor courts have been established in India where there is a dispute between an employee and employer. Where there is an employee who is working in a factory, in an industry, but he has been asked to leave the job. Or his job has been terminated, and he feels that it is wrong, or his salary has not been paid. He's a grievance that my salary has not been paid, or something wrong has happened with his job, or he is being harassed in the job. He can go to labor courts. Disputes between employer and employee. It was established as per the Industrial Disputes Act. The Parliament of India passed an act and made these courts to handle these kinds of cases. And this reduces the workload of civil courts. So whenever there is such a dispute, it has to be filed within 1 year of the dispute. If it is beyond 1 year, the case may not be accepted by the court. So what are the powers of the court? Court can ask the company to take back the employee. You cannot terminate the German job. You have to reinstate. The reinstate means you have to take back the employee, give back the job. Or they can ask the company or the factory owner to give the compensation to the employee, or some other leaves. So disputes are resolved amicably. Amicably means with no problem, no fights, and it protects the workman's right. This is labor courts. Now this is important, family courts. The Government of India, with the powers of the Family Courts Act in 1984, the Parliament of India passed an act called Family Courts Act and established family courts. But why they had to establish family courts other than civil courts? Why? Friends, when cases are being fought in the courts, there's no separate courts. Like same court is working as criminal court when the criminal case is there. Same judge is working there. When a civil matter is there, same part in some part of the court, civil case is being fought. Now, when these family matters are there, family disputes are there, kids are involved, ladies are involved. Now, we don't want to expose them to all that stressful environment of the courts. We don't want them to bring them into that adversarial, intimidating, but threatening environment where criminals are there. We don't want children to be exposed to all that. So to deal with these cases, the family disputes, separate family courts have been established to deal with family-related disputes. Marriage problem is there, marital discord is there, divorce is going on, accusation of harassment is there by husband or wife, a matter of alimony is there, compensation in the marital discord is there, matter of child custody are there. So family courts will deal with these kind of disputes. But these family courts are only in cities where the population is more than 10 lakhs. Mandatory in cities and towns with population more than 1 million, that is equal to 10 lakhs. Most of the other cities don't have separate family courts. Only bigger cities have these separate family courts to handle the family issues. Advantages, it helps in fast settlement because courts are separate, the waiting period is less, speedy settlement. It prevents the families from intimidating environment of the courts, threatening environment, stressful environment of the courts. It reduces formalities and reduces the cost of expenditure. It protects the matrimonial family institutions. Focus on the welfare of children and women is the basis of the family courts. Let's move to the next topic. Executive magistrates. This is an important viva question, students. Sometimes the MCQs also come because we need to understand what is the difference in judicial magistrates and executive magistrates. Now, students, judicial magistrates are judges. Judicial magistrates are lower level judges. These are the lawyers. These are people who are qualified lawyers. They have done their LLB and LLM masters. Then they give judicial services exam, and then they become judges. They are the judicial magistrates. Lower judges are called judicial magistrates. But who are executive magistrates? Executive magistrates are not judges. They are the IAS officers. Senior IAS officers become the district magistrates. They are senior executive officers, executive magistrates. And state public service commission officers who come through the state public service commission, they also become junior level executive magistrates, like they are subdivisional magistrates and tehsildars. Executive magistrates do not have the power to punish. They have no judicial powers. They cannot punish a person for its crime. No. but they have the powers. Their job is to maintain the law and order in the city, in the town. Job of the executive magistrates is to ensure that law and order is maintained in the city. The crime is reduced, the police is doing its job, there's no riot happening in the city. And if they feel that something wrong is going to happen, they can order the police to control it. The main power is to maintain law and order, bind over for keeping peace. The job is to maintain the peace in the city. If there are some unlawful assemblies, if people are collecting against the law and they feel that they're going to do some harm or damage, they can ask the police to remove them. Their job is to prevent public nuisance. They cannot try people for crime or give any punishment to the crime. No, they cannot do that. So this is executive magistrates. Now, juvenile justice board, very, very important. Now, students, a person who is below 18 has been considered child as per the Juvenile Justice Board of India. The Government of India has passed a separate law called Juvenile Justice Act. As per this act, anybody below 18 years of age will be considered child. But why did we need this act? Now the government says, based on the medical evidence, that person who is adult is different from a person who is child. The psychology of a person from adult is different from psychology of a child. So whenever a child has committed a crime, the child needs to be treated differently. An adult committing a crime has to be treated differently from child committing a crime. The laws which are applicable to an adult for committing crime cannot be applicable to child. So that's why we had this Juvenile Justice Act, and the objective is that whenever a child commits a crime, the person below 18 years of age commits a crime, is not a mature person. He is a very immature person. A chance should be given to this person who is below 18 years to improve, to learn from his mistakes, and chance must be given to make this person below 18 years to rehabilitate, to lead a normal life in the normal society. The person below 18 needs to be rehabilitated and not punished. So this is the basic purpose of the Juvenile Justice Board. It was constituted under Juvenile Justice Act to care and protect the children, deals only with children in conflict with law. Conflict with law, those who have broken the law or committed crimes. And who are the members of Juvenile Justice Board? A principal magistrate, that is a first class magistrate, at least with 3 years of experience. So a senior first class magistrate is one of the main members of this board who will take the decisions, and there should be at least 2 social workers who are working for the welfare of the society, and one of them should be a woman who is experienced in child welfare and psychology, who has a better understanding of child psychology, should be the member of Juvenile Justice Board. The function of Juvenile Justice Board to protect the child's right during inquiry, arrest and rehabilitation. When it will be a normal procedure followed. If a child has committed, a 16 or 15-year-old boy has committed a crime, he will be arrested, inquiry will be done, but he will be treated with some care. He will not be treated roughly. He will not be harassed. He will not be tortured. He will be in care. He will be given some benefits. He will be taken care of, and all attempts will be made to rehabilitate him back to normal society. These cases will be adjudicated, ensuring aftercare and reintegration. The liaison, the Juvenile Justice will maintain a liaison with the Child Welfare Committee and focus on rehabilitation over punishment. Instead of trying to punish, the purpose is to rehabilitate the child. So students, this is the last topic for today's lecture. Very, very important, capital punishment. Very commonly asked in exams as Viva question, MCQs and short note. What is capital punishment? Capital punishment means the death punishment. This is the highest punishment which can be given to any other person for his crimes. What can you do? You can take life of that person for committing a crime. Nothing more can be done. So highest punishment which can be given to a criminal is the capital punishment known as death penalty. And this is given in very, very rare cases. Only in very serious, very heinous means something totally not acceptable, very grave crimes. Example, murder. A person has murdered somebody in cold blood. That means he has done a planning, wanted to take a revenge with ill intention, with malefied intention, he has committed a murder. Or only a few cases of rape, only in some cases of rape, like serial rapist. If a person is a serial rapist, can be given the death punishment. Or the person has raped a girl below 12 years of age, can be given death punishment. Or it's a matter of gang rape. So not in all rapes, but in some types of rapes like gang rape, raping a girl below 12 years, or a serial rapist can be given death punishment. And this is as per the section of the Bharatiya Nyaya Sanhita, section 103. Section 103 has described the death punishment for murder, committing of murder. Section 103 of the Bharatiya Nyaya Sanhita. And now what is the method used for that in India? That is the hanging. And now why are we discussing it? Because hanging is the method of giving death punishment in India, but not all over the world. In some countries like United States, in some states of United States of America, some other methods are used, like giving a strong anesthetic to the accused so that he dies peacefully. Or in some states of USA, they give electric shock to the accused person. And some places even shooting is done to kill the accused person. But in India, the answer is hanging by neck till death. Till the person has died, the person will be hanged and doctor will check the person that has died before bringing the body down. So whenever a person is accused, he has to undergo a trial. If the court gives sentence, is convinced that he's done a very serious crime like murder, he can be given death punishment by the Sessions Court. Then that has to be confirmed by the High Court, approved by the High Court, and then the person can be hanged. But sometimes what happens, these people try to save their life by giving mercy petition. कि हम पे दया की जाए. They try to give mercy petition on some grounds to the President of India or to the Governor of the state. Through Governor of the state also has these powers. And Governor of the state will send it to the President of India. And if President of India is convinced, in the consultation with the lawyers and the Government of India, President of India has the power to give mercy, to grant amnesty. Amnesty is possible via President's power. Amnesty means the President has accepted the mercy plea and has reduced the death sentence. Instead of death sentence, he may be given jail. So these are the powers with the President of India. So friends, students, this was my presentation for today. Very important topics. We'll meet again with some important topics from legal procedure. Till then, have a good day. Thank you.